All right. So today's topic is all about the best ways to address tenants' lease violations. I'm going to give you some tips that I recommend to landlords all the time to really help them get ahead of this process, because nothing's worse than kind of getting into a situation where things snowball into a giant mess when you're kind of left regretting not having done something more proactive, more upfront. And so, I want to give you these tips. If you've got situations where you're currently dealing with some of these issues and you have questions that pop up during the live stream, please add them to the chat. I will include them in the Q&A that I will be providing at the end of my talk. I've got multiple questions that were submitted earlier. I've got 9 questions so far, but I'm not afraid to answer your questions. If you throw them into the chat, please do so as we proceed. So if you're asking me, I'm always going to tell landlords that the best approach, always, hands down, the best approach is to deal with lease violations before they happen. If you are addressing potential violations before they ever occur, you're likelier to prevent them from occurring, or at least some of them, right? You're unlikely to prevent every kind of violation. That's just not mathematically plausible. But you might prevent your tenant from, say, getting the idea in their head that they have until the 5th of the month to pay rent. You can emphasize to them in what I call the talk, which is a session that I recommend to all landlords that you have before you ever sign the lease, before you ever hand those keys over to your new tenant. You're sitting them down for this chat, and you're explaining to them all of your expectations. The way you prevent lease violations is to get ahead of it beforehand. Let them know that you will issue written notice upon the commission of a violation, that you will enforce your late fees, that after a number of even non-rent lease violations, the tenant is subject to eviction. And so by getting ahead of this right from the start, you're the likeliest to prevent trouble from occurring, particularly trouble that snowballs into a massive mess. And so have the talk with all of your tenants, be 100% upfront, particularly with your house rules and how you expect your house to be managed. It's not enough that they sign it. You want to look them in the eye and get them to agree, yes, I will follow through with these things. I will pay my rent on or before the first day of the month. I will not prevent you from inspecting the property at least twice in a given 12-month period. I will promptly report any damage that I see on the property to you in writing so that you can come in and make any necessary repairs, and so on and so forth. Whatever your expectations are, if you get ahead of it, you're likelier to have your tenant comply with the lease than if you just leave it to them to read and then follow what's in the document. Because newsflash, most people don't read the things they sign. And so unless you have a talk with them, they're not likely going to read the black and white from start to finish. And even if they do, they might not understand it. You having this conversation with them is going to go a long, long way. So in terms of another tip on how to deal with lease violations, one easy one, absolutely, you deal with them immediately. Don't let time pass. If you wait too long before you start documenting lease violations, I promise you, a court's not going to care. And if you need the help of a court, it doesn't matter that they are currently in violation. If you can't prove that you addressed something with immediacy, then the court might not care that, again, something happened a year ago or 2 years ago because you didn't address it then. And all of a sudden now you're bothered by it. Now, and some of you are smart and some of you are Ernie, but I've got a provision in my lease that says I don't waive any of my rights, even if I don't enforce them. And that's 100% probably true. If it's in your lease and it says if there's a non-waiver clause, I don't waive anything. The problem is in a practical setting when you're in front of a judge, if you are trying to talk about things that happened a year or 2 years ago, and whether it means that you can today request possession, it's unlikely to hold a whole lot of water because you just waited too long. If you're going to deal with lease violations, do it immediately. And my third point is do it in writing. Make sure that when you address a lease violation, it's not just by spoken word. It's not just a stern talking to on the phone. You are issuing written notice of default. This is extremely important if you later mean to build a case before a court where you gave reasonable notice for the tenant to fix whatever problem they were causing or whatever violation they committed. You gave them written notice and gave them a reasonable opportunity to correct whatever the behavior was or the damage maybe that they caused. By showing a court that you gave this reasonable written notice in accordance with your lease, you're likelier to be successful if later you have to kick them out. Number four, the fourth thing that I recommend, so you're going to want to get ahead of it and talk beforehand about any potential violations. You want to be immediate with your response, and you want that response to be in writing. Number four, you want to follow up. Absolutely. And so, when I talk to landlords about this, I constantly talk about that thing that they want to address. And so if, for example, it's a matter of cutting the grass, and you say, look, I'm going to give you 3 days. You're in violation of your lease by not cutting the grass every X number of days or X number of weeks in accordance with the lease. I went by and the grass is up to here. I'm going to give you 3 days to get that cut before I issue another violation. Now, if you don't come back for another month, it's virtually meaningless. What if they go a whole other month and you come back? You've already been damaged. You're probably getting letters from your HOA and maybe even fines from your HOA. And you've shown the tenant you're not super interested in your own deadlines. If you give a hard deadline, make sure you're there on day 4 or shortly after to see if they actually did the thing. If they didn't do it, then you cite them again. You give them another notice and say, look, I previously came. I gave you reasonable notice. You are now further in violation. Please get it done. I'm going to come back in 4 days. Get this done in 3 days. Or maybe you shorten the window. You say, get this done in 24 hours, or I'm going to do it and cite you again or charge you for my services. And so, you want to follow up, and then you want to follow through with consequences. So it's not enough to get ahead of it. It's not enough to immediately address something. It's not enough to just send notice in writing and then follow up if there are no consequences. So the last tip that I have for you landlords is make sure there are always consequences for lease violations. I don't know how many times I talk to landlords who say, well, I don't feel right assessing late fees. You got to get out of your feelings. And you got to let the tenant know if by this date you haven't paid, you're going to owe late fees. It's in the contract, and I will enforce that provision. Make sure that you are doing this. Make sure that if they have violated the lease in some kind of non-rent way, that you're issuing written notice. And make sure that they know that additional notices could come with a notice to vacate, which is you terminating the lease and say, sorry, it's over. Don't just threaten it. Threats only go so far. And I guarantee you, if every month you're giving the same threat and no result comes from it, there is no consequence, it's meaningless. Your tenant knows it and you know it, that you don't actually mean you're going to evict them if you don't actually follow through with it. So don't just follow up. Make sure you are following through with a consequence if the tenant has continued to violate it after you've followed up, after you've given notice, after you've addressed it immediately, and after you've had the talk with them where you've laid out your expectations for them. I promise you, if you do these things in this order, in fact, if you get ahead of it, you're going to prevent most of the defaults. And if you address things immediately and you issue written notice and you follow up and you always end with a consequence, if it is, again, appropriate for your lease, then fewer of these things are going to happen. But if they keep happening, then you're going to follow through and ultimately send that notice to vacate, get rid of that tenant, put somebody in who's going to treat your property, your property with respect, who's going to honor the written agreement, and who ultimately is going to help you in your goal of actually making money in this business. And so I appreciate those of you who've hung on all the way through the end. I will now get to the questions, and then anything else that pops up during this Q&A time, let me know, and I'll be happy to answer that to the best of my ability. I am no rocket scientist, no rocket questions, please. So Tippy asks in the chat, I just received a lease violation with about 6 allegations, all made up by a retaliatory property manager, angry because I complained about mold. So obviously this is from a tenant perspective, but I'm happy to answer it. So let's see. Received lease violations with about 6 allegations, all made up. Well, here's the thing. If you made a valid mold complaint and a landlord or their property manager retaliates against you, you have rights under the law. If you can prove to a court that these acts were taken in retaliation, follow whatever your local jurisdiction says about filing a lawsuit against this individual. That's not the correct way to manage property. However, if the allegations are correct, and even if you made a mold claim, it might be complicated for you to seek redress from the court if you are already in some kind of violation. I know that in Texas, for example, the fact of non-payment might remove the obligation on the part of the landlord to address certain repairs. And so you want to make sure that whatever it is you're presenting to the court is your strongest case. But if you've got a strong case and a landlord is acting in a retaliatory manner, make sure you follow the lease for presenting that mold claim. And if you have a defect on the property that affects your health or safety in a material way in the state of Texas, you do have remedies that are available to you. On the flip side, landlords, whenever you do have these mold claims that are made, it's always my recommendation that you get out, you go check it out, and you assess the damage. Sometimes mold really isn't that big of a problem, or it's a problem that you can easily clear up. So don't let it turn into something big, but make sure that when you have a mold claim, a valid one, that you're out there addressing it. As far as retaliation, of course, I'm going to tell you that's never a good idea. Don't retaliate against tenants, but these are serious claims, both the claim of mold and the claim of retaliation. If you have evidence of these, the courts can address those. So going on, War Clan says, can you evict a tenant for late payment fees? So in Texas, you can't. If all it is fees, whether it's HOA fees or repair costs, maybe they didn't finish paying the security deposit, maybe you collect their utilities, none of these are a valid basis for an eviction. However, one thing that you could do is, say in the month of January, last month, a tenant had certain unpaid fees, and then in the month of February, they submitted payment. They didn't include anything for those fees. Well, if you have a clause in your lease that allows you to apply payment first to old debt and then the balance to rent, now you've got a non-payment of rent issue because you've collected that payment, but because they had a pending debt from last month, you've cleared that part out first. And let's say there's a balance for the month of February. You send notice to the tenant saying, look, you submitted an incomplete payment. Thank you for clearing all of the fees from last month, but you haven't finished paying the rent because those fees were owed. You paid them, but you didn't pay to the full extent of what was owed. In Texas, that is a valid claim, a claim for unpaid rent. If all you've got are fees, you can't run to the courthouse yet. In Texas, it has to be non-payment of rent. And you got to do good accounting to make sure that you're applying these funds this way all the time so that you can prove to the court precisely what's owed and precisely that it is rent in question. All right, Tip, you have another issue about your landlord. My recommendation, if you've got an ongoing, very specific issue and not a general question, that you seek out local counsel in your jurisdiction. I don't know if you're in Texas, but these rules are very particular and very state specific. So if you are in Texas, then definitely a Texas attorney can help. If you're outside of Texas, I really don't have procedural advice, to prove retaliation, to prove, some of these things. You're going to want to talk to a legal professional in your jurisdiction. Warclan continues, how can you collect late payment fees from a current or evicted tenant? Well, if they're a current tenant and they owe you a subsequent month's rent, you can collect them at that subsequent month, again, if you have that application of funds clause. If they have been evicted and are no longer there, you can potentially get it out of the security deposit. But if that's gone, then it's complicated. And what I tell landlords is, look, the fight to go and collect fees that you are owed against someone who has no capacity to pay them is not a very good fight. And so the best time to collect these fees is while the tenant is in place. That's when you have the most control over the situation. Once they're gone, it's going to be very hard. And the fact that you might be able to successfully sue these people may not amount to much if you can't ultimately collect on the judgment. You might have a nice piece of paper that says you've got a judgment and that you won, but you might not be able to get farther than that. Okay. Like Sabay 99, my tenants have paid on the 6th or 7th half of the time since their lease started. Do you have suggestions to get them to pay on time more often? They have paid all late fees as well. Well, the fact that they're paying late fees too tells you two things. Number one, they are cognizant of it and they're willing to pay what they owe. But timeliness should also be featured as an issue in your lease. I don't know what your lease says, but if it says something like our leases, it says that rent is due on or before the first day of the month. The assessment of fees isn't an extension of the rent due date. It is an additional authority that a landlord might have if the landlord continues to accept the rent from you as a tenant. That being said, if you want the rent and you want the fees and you accept it, well, then you're kind of waiving that claim. But you can give them written notice and say, look, I've accepted rent up until now, but each time you've paid by the 6th or the 7th, you've technically been in violation. Please refrain from that. And in the future, make sure you submit your payment on or before the 1st of the month. And then follow up. And then if there is no change in this behavior, it should have a consequence. One easy consequence is at the time of lease renewal, your tenant has clearly indicated to you that you're just not charging them enough money for rent. Make sure that you raise the rent amount. And if they pay the higher rent with additional late fees, well, now you're being compensated for that difference. Whether you want to keep them or not is an entirely different thing. But that's one easy consequence. Again, if you're going to renew their lease because they're otherwise good tenants, make sure that you make a raise in that rent commensurate to what they're already paying anyway, because you know they can afford it. But give them written notice. Make sure you follow up with them. Let them know that if this continues, it could lead to eviction, and that your preference is that the lease is followed in all respects, including, in this specific case, timely payment. Follow up, but you got to issue that written notice and you got to address it. And again, don't wait 6 or 7 months in. Make sure you're addressing it right out of the gate the first time it happens. James E, can a tenant pay 6 months or a year in advance if they want? They definitely can. I've got a video on my page that addresses, early upfront payment and the kinds of pitfalls that may or may not come with that. It could sound like a blessing, But sometimes it ends up being a curse if you don't know what to look for. Absolutely, it's an option. And definitely there are landlords who operate in this way. And it can work out quite well. You just have to stay on top of the leasehold and make sure that everything's A-okay on the property, so that you don't get wrapped up in some problem and think, oh, well, I don't have to look back at the property over the next 12 months because they paid a whole year in advance. That's a mistake. Always a mistake. Okay. So War Clan is back. Is there a limit for secure deposit tenants can request in Texas? Oh, for security deposits. Usually 1 or 2 months of rent, but some precincts take more than 1 month due to volume and court delays, writ of possession, etc. I meant for more than 1 month to evict. There is no limit on security deposit in Texas. Generally speaking, it's 1 or 2 months. I've seen it go as high as 3 months in certain situations. But really, the key is just staying on top of it and evicting fast if the situation calls for it. Send written notice, send written notice, send written notice. Make sure that you're on top of that. And the first month that you go 7 days without full payment, that's somebody you need to evict. Because if you haven't gotten the rent by day 7 of the month, inevitably, even if it gets paid that day or later, there's going to be an impact on the following month. You never want to go past 7 days. You want to move past that person. Get started with eviction quicker. Get people out quicker. But yeah, the higher you go with your security deposit, the less likely you're going to find applicants who are willing to do that. James, no worries there. I always inspect my properties about twice a year. Good job. That is an excellent idea. And that's precisely what we recommend. At least twice a year, every time. Make sure you're on there. Rachel Lopez says, hi, just joined. Have you answered the questions on Facebook? Mine was one of them. Rachel, I haven't gotten started. I've had so many questions here on the live chat, and I'm going to take a break after I go to Adrian. Are lease agreements something you and your team do for landlords? Absolutely. In fact, if you look in the description of this video below and in really all of our videos, among the things that we offer is a residential lease. If you are interested in us drafting and creating a tailor-made residential lease for you, we're happy to do it. We offer the lease, we offer various addenda that come along with it, and you get 30 minutes with a licensed attorney where we'll walk you through what the lease means and how we can tailor it to your needs. And so if you're interested in that, there's a link below with a description of the service. We do offer leases routinely for landlords in Texas, and we are happy to help. All right. Let's go to those questions that we got asked early on. Kelly Martinez Miller asks, Law Office of Ernie Garcia, tenant didn't pay the ordered whole month's rent yesterday. Can he still pay late, or how soon can we get him out? Tenant didn't pay the ordered whole month's rent yesterday. Can he still pay late, or how soon can we get him out? Just wait on the guy to file the writ. Tenant has fought us tooth and nail to stay in our house rent-free and believes he has the right to live there. It sounds like there's a few pieces of information that are missing from this question that I think I know what's missing. It sounds like there was an eviction and an eviction appeal, and that the tenant was required to pay rent into the court's registry, didn't pay it, and now you are eligible for a writ of possession. So can a tenant pay late? Generally, once that writ order is signed, no. Up until the writ order, it's all up to the judge. Generally speaking, the justice of the peace will not allow extra time. If there's a hard deadline at the justice court and they don't meet it, you get your writ and you're done. If it's at the county court level, we have found that on the county court level, the courts tend to be a little more lenient, particularly because, number one, they get 5 extra days. If it's due on the 1st, they get 5 extra days in Texas. Additionally, after that, you have to set a hearing. And if at the time of the hearing, the judge is feeling particularly generous with your property, by the way, they might give them a few extra days to pay and say, look, I'm going to sign this order for an immediate writ unless you pay by the end of the week. And these are common things. I often tell landlords in these situations, look, if they run to the courthouse and pay, they're going to stay. But guess what? If we lapse into another month while the appeal is pending, if we lapse into another month, we're going to do it again. We're going to require that they pay the full amount within the first 5 days, or we're going to be in front of the judge again demanding that payment. So it's a process. Again, at the Justice Court, generally, there is no extension of time. The county court level there can be. But once that order is signed, that's pretty much it. Ty Dow asked, just when I need most. Thanks. Here's the scenario. Tenant paid this month and moved out. He wants the key back to go clean the house. Bad idea. After I said I have scheduled professional cleaning, he also wants to handle the repair for the house. Small repair. Bad idea. Don't let tenants do repairs. He was mean, very demanding, kind of talked over us during the lease. He sent an HVAC guy to fix the HVAC. He wouldn't let the poor man use the restroom. Oh, we sent an HVAC guy. He wouldn't let him use the restroom. He was not cooperative when we requested to remove an unauthorized pet and when asked for identification of the unauthorized occupant. Now he keeps calling, yelling, asking for the deposit while we just barely started the inspection of the house and now waiting for a quote from a contractor. He didn't provide us with a forwarding address either. This sounds like a terrible, terrible tenant. I'm happy for you that you were able to get rid of him. He installed and removed security panel and camera on the wall. It doesn't cost much. It can be waived. However, the house needs a deep cleaning. Costs $400 to have it cleaned. Questions. Do I have to give him a key to the house? And he doesn't miss, as he doesn't miss any rent. The lease will not be expired until the end of the month. Okay, so first, if he already surrendered possession and turned in the key, no, he is done. The lease is over. Even if he's paid up all the way through the end of February, once he surrenders possession, turns in that key, moves all his stuff out, he's done. You do not have to give him access again, because the last thing you want is to give him a key and he moves all his stuff back in. So no, I would not allow him back in. Read your lease and see if it has a definition of surrender. If you're in Texas and you're using a lease that has a move out section, you're likely to find it there. Second question, how to address the unauthorized pet and person that used to live there with the tenant. We collected $500 initial charge for the pet, but didn't collect the daily charge. The unauthorized pet and the occupant stayed with the tenant until they moved out together. Well, this has more to do with your implementation of these provisions during the tenancy. And I don't know how many days this dog was there. I don't know what all you can prove. And so a court's only going to assess a reasonable fee for these violations. So if he had a dog in there for 250 days and you really didn't do anything about it, I don't know that the court's going to bail you out. You can charge your actual damage. Did this animal cause actual harm to the property? That's always on the table. And whether you take that out of the security deposit or you take that out of, or you recover it in some future lawsuit against this tenant, that's completely up to you. As far as the unauthorized individual, if you allowed them to stay there, the consequence for this is that it is breach. Did you send a written notice? Did you threaten to evict? Did you actually evict? If you didn't, then again, unless that individual themselves caused harm to the property, there's really no way to gauge a dollar value for them being there. The problem for them would have been the threat of eviction, but it doesn't sound like that actually occurred. Let's move on. Amy Hopkins asks, tenant left the house with major damage, over $2,000, stole landlord's personal property, didn't give 30 days notice, didn't pay the last month of rent. How long does the landlord have to take them to small claims court? So by default, you've got 4 years. I don't recommend waiting for 4 years. That's not going to be a good idea. Instead, I would say get on it ASAP. Do you know where this former tenant currently resides or works? Because guess what? You can sue them and serve them notice at their place of business if you happen to know where that is. If you know where they reside because they gave you a forwarding address, make sure within the first 30 days you send them an itemized notice of the current damages that you are aware of. Mention the $2,000 in repairs to the home. Mention the unpaid rent. Mention all the fees that you can compile, that you can justify from your lease and the leasehold, the damage caused by the tenant, and mention that in your notice so that they don't sue you first for wrongful withholding of the deposit. You've got 4 years total. I recommend always going to the court within the first 6 months. And there's a number of reasons for that. First, you're going to want to document everything with video and photographs. Keep all of your receipts because it's easier to prove the damages that you paid for as opposed to something that's a mere estimate, especially if between the damage and trial, you didn't actually repair anything, and now a new tenant is in place. That's going to spoil all of your evidence and really make it hard for you to prove your damage. Get everything fixed. Make sure you have proof of the cost that you incurred in fixing that unit, then put a new tenant in there and move on. But my recommendation, do it within the first 6 months. Okay, Bedzendara Garcia Hamilton says, no questions today, just saying thank you for your videos and knowledge that you share here. I successfully recorded an abstract of judgment for the judgment I won with eviction. Whoop, whoop. Good for you. Now I'm taking the tenant to small claims court for all the damage that he caused. Well, I appreciate you being appreciative of us and what we do here. For those of you who don't know, we got a ton of free content on this channel. I welcome you both to join us in these live YouTube events, but also to check out what we've already pre-recorded, over 800 videos with all sorts of really, really good stuff. Bobby Lou asks, do I get to keep the deposit if the tenant breaks the lease and moves out a couple of months before the lease end date? Ooh, this is a juicy question, and we get this so much because there is a misconception out there that because the tenant breached, they automatically waive their deposit. And I'm here to tell you, Bobby, that just is not true. It doesn't mean they haven't caused you harm, but you have to calculate the total value of the harm, and that value must exceed the deposit for you to say that all of the deposit was fairly applied to this economic harm. If you can't do that, you can't keep it. So let me make things really easy for you. Let's say the tenant moves out and they've got 2 months left on their lease and they cause $500 worth of damage. Now they've got a $2,000 deposit and the rent is $2,000 a month. Let's do some math. $2,000 a month for 2 months is $4,000 plus $500, you have $4,500 worth of damage. A $2,000 security deposit gets wiped out. And so easy peasy lemon squeezy, right? Now, let's say that the scenario involves your obligation also, because just looking at that, it's like, that's easy. And sometimes landlords stop there. But in Texas, for sure, and across the country, in many other situations, the landlord has a duty to mitigate their damages, which means you got to take reasonable steps to find a replacement tenant. And so let's say it took the full 2 months. Well, in that case, 60 days later, after you made a diligent effort to go and find a new tenant, you can recover the full 2 months plus the $500 in damage. You're done. But what if it took you 5 days? 5 days, you fix the $500 worth of damage, and the perfect tenant strolls over. They pass your application process with flying colors. They pay you the first month and security deposit. Well, what are your damages for 5 days at a $2,000 rent? It's about 1/6 of that, or about $350, give or take. So $350 and $500 in damage. Now that amount only gets to $850. With a $2,000 deposit, guess what? You actually owe them a refund. Now, again, this scenario presupposes only $500 worth of damage and only $350 worth of unpaid rent. Remember, the house was only vacant for 5 days in this particular scenario. That's not usually the case, but you need to know the full extent of your damage, and only it can be properly subtracted from any security deposit that you hold. A big one is going to be, do you have reletting costs? Do you have advertising costs? Maybe you pay someone to list the property, and maybe that cost is a full month worth of rent. That alone could wipe out the security deposit. But make sure you can articulate these actual costs when you send your 30-day notice, explaining to the tenant how all of their deposit funds were properly withdrawn and were applied to the amounts that were owed. Unpaid rent, damage to the property, maybe the cost to relet. All these things can be included, but make sure that you can articulate those. So, very common question. It happens a lot. It's not automatic, but generally speaking, you're going to have enough damage to wipe out that security deposit. You just better be able to prove it. Otherwise, you could be in a mess of trouble. All right, Jose Lira. Rent is due on the 1st. Amen. Grace period is through the 3rd. Probably not. If you're in Texas, there is no grace period on the rent due date. I always want to get ahead of this and just say that up front. No grace period in the state of Texas. But I'm going to move on. Tenants, as of recently, have been bringing the rent on the 5th through the 8th. What type of notice should I issue, and how should I deliver that notice? I'm planning to do a to-cure notice or a default notice on the 4th and do regular mail only, or should this also be certified, or just hand delivered to the tenant when they come to pay the rent? I'm wanting to prepare my paper trail in case I need it in the future. These are excellent questions. Understand that if your lease says rent is due on or before the 1st of the month, then on day 2, they are technically in breach for not timely paying the rent. Now, if your lease says, but you have a grace period until whenever, well, unless your state requires that, I know Texas doesn't, I don't recommend language like that at all in your lease. But if it's there, it's there. But by default, it should say the rent is due on or before the 1st and must be paid on time. So by the 2nd, it's technically late. In Texas, however, you cannot assess late fees until after the 3rd day of the month. So on the 4th and thereafter, you can assess late fees. But again, as I've mentioned so many times, that does not extend the due date for the payment of rent. So even if they pay it on the 4th or the 3rd or the 5th or the 8th, whichever, you're issuing a notice of default that says rent is due, again, assuming this is what your lease says, on or before the 1st day of the month. Timely payment of rent is expected. If you continue to pay rent late, you may be issued further notices and ultimately may be issued a notice to vacate with a termination of this lease. And just remind them that these lease violations are important, and they are, again, if they stack up, potentially the building blocks to a great eviction case. And so hopefully you are assessing late fees every single time, but definitely issue these notices. Now, how to deliver them? You can definitely deliver these notices by regular and certified mail. That's helpful. Check what your lease says about email. You might be able to, even in the state of Texas, issue a notice of default through email. Now, what I tell landlords all the time is if you plan on issuing this notice or you plan on presenting this notice to a court, do it in every way possible that's reasonable and traceable. Do it through regular mail, do it through certified mail, and do it through email so that you can prove to the court that you sent it in multiple ways. Do you have a personal email and a work email? Do both. Did both spouses sign the lease and both of them have personal and business emails? Look at that. You've got way more access to the tenant, and you can definitely prove that you sent that notice if you send it in these various ways. I think email is a great way to deliver notices like this. In Texas, a notice to vacate is of no effect if it is only sent by email, but you can send a notice to vacate by regular and certified mail and slip another one in through the email. It doesn't hurt, doesn't help, except that it gets there really fast, right? So it doesn't help your eviction case, but it might help in terms of your management of this rental. And you might get a quicker response. You might get a move out, that sort of thing that wouldn't require the filing. So I like delivery by email, but make sure that it is in your lease as an available method of delivery of notices. All right, Ty Dow is back. Ty Dow asks, tenant constantly ignores the HOA rules about trash and disposal. The HOA keeps sending violation notice and charging fees for every violation. Tenant refuses to comply, refuses to pay the HOA fees while still paying their rent on time. What is the chance of getting tenant evicted or getting them to respect the HOA rules and pay for their penalties? It's all on you. If it's in the lease, you have to enforce that section of the lease. You have to issue notice of vacate. You have to issue notices of default for each of these violations. And you got to give them a reasonable amount of time to pay. If they have a stack of 3 HOA violations they have not paid, you need to send them today through regular and certified mail with copies of the letters. And in your letter, make sure it is absolutely clear. They've got 7 days or 10 days to pay X, whatever that total is. Give them a reasonable opportunity to do it, and then follow up. And if they don't do it, send it again. Send it again and again and again. I preach a 3 strikes and you're out philosophy. If they refuse after good written notice is sent to them and they're given a reasonable opportunity to cure, well, come March 1st when they pay the rent, if you have an application of funds clause, you could potentially draw those payments there first and say, thanks for paying these fees that you owe. Now you have a rent deficit. And perhaps at that point, they either pay the balance or they say, you know what, if you want to evict me, evict me. Guess what? If you've already laid the groundwork for all of these violations and all of these fees, and neglect can be proven because you sent reasonable notice over and over and over, and now they refuse to pay the rent balance, you've got a pretty good claim for eviction. But you have to enforce your lease with written notice and then follow up and follow up and follow up. Best of luck to you, Ty. Tessa Gale asks, tenant is only past due $279. Won't pay until the mold in the AC vent is fixed and the AC is fixed that's causing the mold. What notice can be given to vacate? Can they appeal? That and sue over the mold? Mold inspector's test shows not black mold and mold not at elevated levels. Okay, so I'm presuming you're asking from a Texas perspective, because that's going to be your best bet to get a good answer out of me. Number one, a tenant cannot withhold any portion of the rent for a repair request. And so if they're doing this, you can issue just a standard notice to vacate for non-payment of rent. Now, they may say, oh, you're retaliating against me because I made a mold complaint. But the code specifically says that non-payment of rent and an issuance of a notice to vacate for non-payment of rent is textbook non-retaliation. It's not a retaliatory act to say you have to pay the rent. And in this case, they do. Now, can they sue you for this repair issue? It depends. Were you diligent in the repair? Are you still in the middle of the repair? If you can prove to the court, number one, that you have responded to this claim and you are in the process of dealing with it, that lawsuit probably isn't going anywhere. Additionally, if they can't prove, and it sounds like you may have some scientific evidence that they can't prove that whatever defect exists materially affected their health or safety. Again, if they can't meet that minimum threshold, then you don't really have a duty upon which they can sue you. Right? So they definitely don't have the right to just withhold rent. But they definitely have the right to sue you in court, but they would have to prove that they meet these minimum thresholds. I don't have enough in your question to be able to tell you whether they've met that, whether they've sent proper notice as required by the code and given you a reasonable amount of time to complete these repairs. Again, in Texas, these are very specific and requisites for them to be able to take legal action against you. I don't know if this has happened, but if it hasn't, and you're still in the process of repair, chances are number one, you can evict them for non-payment, and number two, they wouldn't be successful against you in a repair and remedy claim because you're acting with diligence. Okay, so now we get to Rachel Aponte. Her first eviction. All right. Once the tenant did not file an appeal, how soon can I file in small claims court? She broke all my windows in the unit, destroyed it. The judgment was given February 3rd of 2025. Says no writ until February 12th. That's today. She told the judge she was no longer on my property. Do I still need a writ? Well, you need to confirm that she's not on your property. And not on your property means she's gone and all her stuff is gone. Because if her stuff is still there, she's still there. And in that case, I would suggest getting a writ so that the court can allow you, once that writ is exercised, to gather all that stuff and throw it out. Or give her an opportunity to clear it out ahead of time. You don't want to deal with some kind of claim that, oh my gosh, you touched my stuff before I was able to take it. My grandmother's $10,000 brooch was there, and now you owe me $10,000. So if her stuff is there, I would suggest purchasing the writ and then having the writ executed so that you can pull it all out, throw it away, and be done with it. But if it's completely vacant, yes, go to the property, change the locks, recover possession, fix those windows, and then decide whether it makes good sense to actually go after this individual with your lawsuit. Because remember, you really got to think of two things here, Rachel. The big questions are: can you find the tenant? Do you know where she resides or where she works? And does it make sense to sue her? Does she have the capacity to pay you these sums? If she doesn't, or you can't find her, I don't know how valuable that lawsuit would be. Because if you can't find her, you can't serve her. If you can't serve her, you can't win your lawsuit. Your lawsuit doesn't go anywhere. Now, if she has the capacity to pay, and you know she does, and you can't find her, there are services out there that can assist you to track people down. So that's also an option. Okay. So okay. So Tao Dao says she missed the live stream. Well, guess what? You're lucky. This whole thing will rebroadcast. You'll get to watch the whole thing. I promise. You might have to give it some time. I don't exactly know how much time you have to wait, but you will have an opportunity to see the whole broadcast all over again. I promise. Have Ernie get my question about the tenant. I promise you I addressed all the questions that I had on my list. On the replay, you'll get to see it. Sorry that you missed it earlier. James says, if a tenant has clearly moved out but has left a few minor items such as clothes, some food in the fridge, can I throw these items away? So minor items could be abandoned items. But again, it could be that they're coming back for them. So if your lease has an abandonment provision, it might have a procedure that you can follow in which you give your tenant reasonable notice. And so you leave reasonable notice to them. And again, email, work, personal email, post it on the inside, post it on the outside of the main entry door, text it to them, say, look, it looks like you left a few things. I'm going to give you 48 hours to come and collect these things. However, if I don't hear from you in the 48 hours and you haven't collected them after that time, I'm going to assume you have abandoned these items and that I am at liberty to simply dispose of them as I see fit. So put that in writing, give them a reasonable amount of time to come and get the rest of it. If you hear nothing from them, I wouldn't go at 24.01 hours. I'd wait a whole other day or two just in case. And then if they haven't come back, they haven't notified you in any way, and you have sent notice in writing to them in some demonstrable way, go in there, clean it out, you're done. Okay. Hi, Olga. Sorry that I'm coming to you a little late, but I see your hi, Ernie, there, and just wanted to say hi. Tao, back in the same scenario. When tenant paid, moved around January, lease expires at the end of February, do I have to return the February rent he paid if we refuse to let tenant come back? Okay. So that was part of the scenario that I didn't quite understand. So the lease expires here. If the tenant surrendered possession, you don't owe him anything. He owed to the end of the month. If he's out, he surrendered possession. Again, look in your lease for a definition of what surrender is. If they did that, they're done. They don't have a right to come back. You can allow them back if you want to as a courtesy, but I wouldn't do that without supervising them and making sure they're not moving back in. I wouldn't just give them the key and just give it back to me later. I wouldn't do that. I would open it. I would wait there for them to do whatever it is they're going to do. And then when they're gone, lock it back up, change the locks, don't let them back in. Again, there's just too much risk to give it to them unsupervised, which I don't recommend. All right, Carolyn Conray, what is the maximum late fee allowed monthly for late rent payment in Texas? Great question. We get this a lot. So it depends on the unit. For a single family home, which could be up to a building with 4 units in it, so a quadruplex is still technically considered a single family home for each of the individual units. You can charge up to 12%. That's a good rule of thumb, 12% in late fees of whatever the rent is for that month. So if you have, we're going to just make the math easy, a $1,000 rent, you can charge $120 maximum. So that's if you have a single family home, an individual house, a duplex, a triplex, or a quadruplex. All of that's a single family home. You can charge up to 12% of the rent. Now for you brainiacs out there, well, but Ernie, I know that technically you can charge more if you can prove, yeah. But don't, unless you know how to do this, unless you are a brainiac, I wouldn't fiddle around with this. The code maxes it at 12% unless you can prove otherwise. Again, leave that for the brainiacs. 12% is your rule of thumb. And what I recommend to landlords, particularly in Texas, when you can't assess rent until the 4th day, then on day 4, it's 3%, day 5, 3%, 6, 3%, and day 7, 3%. So that during these 4 days, you're collecting all 12% of your rent. And that's where my philosophy comes up. If you haven't received everything within 7 days, notice to vacate. Make sure they're out, because by that point, you've maxed out your late fee and you've waited too long. Waiting any longer is inevitably going to negatively impact the following month. All right, WarClan is back. Eviction or late payment notice to tenants can be part at the door taped, backed up by a photo signed affidavit of the delivery. I don't recommend that at all. If you're going to deliver a notice to vacate, my strong suggestion is that you send it by regular and certified mail. These are trackable, traceable, and subject to a lot less scrutiny than this. Especially if you're taping it to the outside. The state of Texas does not like taping the notice to the outside. You need to meet a laundry list of requirements, any of which, if you get wrong, invalidates notice. Don't subject yourself to that. The other option is to open the door, and on the inside of the main entry door, you firmly affix a copy of your notice. That's possible, but it comes with its own risks, especially if you have a hostile tenant. So the best bet, if you can open it and put it on the inside, yes, that counts. But I still would recommend regular and certified mail. The courts love the mail for some reason, and so it's always our go-to in order to prove that we sent it. Certified letters sometimes are not intentionally signed for reception or accepted by tenants. Can these be accepted in court if this happens during the eviction as part of notice? Yes, because along with the tracking of your certified letter, you're going to get an update that shows when delivery was attempted. In a few cases, about 10% of the time, the certified letter actually gets delivered. We find that 90% of these never get delivered, but the tracking will show when notice was first attempted delivered. And what we know is if we send both letters at the same time to the same post office, they're going to go together with the letter carrier on the same day. And while the letter carrier will attempt to deliver the certified letter, the letter carrier will certainly and successfully deliver the regular letter in the mailbox on that date. We call that day 0. the date of delivery of the regular letter, and then thereafter we count 1, 2, 3, if it's a 3-day notice to vacate, and on day 4, we file. And so that's how we use that data to set ourselves up for maximum impact and proof that we actually delivered our notice. Kay Miller says, Kelly here. Yes, you figured it out. LOL. I was handling a 3-year-old and typing with my voice. All right. I'm glad it worked out. Adrian's back. If I tried to file a small claims on my previous tenant and I have their information except their new address and workplace, a private investigator can't find them? Is that the end of the road? I don't know that I would hire a private investigator. We do something called a skip trace, which is widely available. And so what tends to happen is when people move, they're going to get a new cell phone bill or register to vote or a new utility or some other identifier that'll make them findable in certain public data searches. It might take a few months for those databases to catch up, but eventually they are findable if they are in the same state. If they've left the state, you can still do this search, but it gets much harder. And so if it turns out you absolutely cannot find this person, they're lost in the wind, then yeah, that might be the end of the road. Okay, Rachel Lopez, what happened when they are to pay you the rent owed? Judgment 1, next step, how do I collect the money? What happened when they are to pay you the rent owed? Judgment 1, oh, I see. So you've secured a judgment, but how do you collect? Well, there's a couple of ways. The easy way is to reach out to them and say, hey, do you want to pay this money? I'll release the judgment so you don't have this eviction on your record. That sometimes works, not very often. Another effective way is to create a judgment lien. That's where an abstract comes into play. If you file an abstract of judgment, you win the judgment, you request an abstract of judgment from the court. This is the Texas procedure. You take that and you record it with the property clerk's records. Just like you would a deed or a lien, your title records go there. You can record your abstract there, and that creates a judgment lien on the tenant. Now, whenever they want to go buy a house, maybe 5 or 7 years down the way, they're going to find when they do a search on this individual that they have a judgment recorded against them that has since grown with interest. And guess what? If I file that lien, I'm going to get a call. And they're going to say, Mr. Garcia, can you please tell us what it's going to cost to release this judgment? We have someone here who's trying to buy a house and wants to release the judgment. That's when I call my client and say, hey, looks like we're going to collect on that judgment. Do you authorize me to put that into place? They say yes all the time. I call them back and say, yep, we can go ahead and take care of this. Send it to me and I will release the judgment upon receipt of payment. So one effective way is to abstract the judgment, and then now it's part of their credit history, and I say it's part of their credit history. Judgments are no longer technically found after 2018. They're no longer technically found on credit reports, but by recording this judgment, the abstract of judgment, now you have something that's searchable, particularly to title companies when someone buys a house. And so this is an effective way of getting from someone who has the capacity to pay. Remember, anybody who doesn't have a capacity to pay, you're never going to collect that judgment from them. So if they do, and they later want to buy property, maybe they want to buy a car and secure a car loan, or they want to buy a house and secure a home loan, that's when a well-recorded abstract of judgment really is at maximum benefit. Okay, how about ledgers? Can it be on my computer, or do you recommend both? If you're talking about rent ledgers, yes, I do recommend keeping accurate rent ledgers. You could do it as simple as an Excel spreadsheet. That's absolutely okay, but make sure you're doing it. Some people will handwrite their notes in a spiral notebook, or they'll keep a receipt book, but make sure you have some kind of recorded instrument to keep track of all the payments so that you can prove that to a court should you need to. In Texas, if you receive cash payments and you don't have a record and you don't supply receipts to your tenant, guess what? in any eviction, you might be unable to prove your claim because you lack that evidence. And that's a huge problem. You might, in fact, end up owing the tenant their legal fees because you lack proper evidence to prove that claim because you accept cash payments. Yet another reason why I'm not a big fan of cash payments. But yeah, that's the law in Texas. Oh, Tao, how much is your fee to do a series LLC with 5 sub LLCs? So series LLCs are not something that I do. That's something that we would refer out to a business law firm. But thank you for asking. Rachel, thank you. Good info. Oh, well, you're very welcome. Adrian, Ernie, does your office offer services for skip trace so I can provide information to the court so they can be served, or can your offices serve them? Yes, we can assist you with a skip trace. Feel free to shoot me an email or give us a call, and we can assist with that process. If you're looking to sue, we can arrange for service once we find the data from the skip trace. If you're looking to collect on an abstract and maybe you want to serve a writ of execution, again, the skip trace is helpful so that we can arrange for service of that document if you're looking to collect on a judgment. All right, looks like we have the last question. Tao Dao, I just found out that the CO2/smoke detectors are older than 10 years old. What are the odds that the tenant uses it against landlords even if there is no incident or gas leak? Not high. If you know that's the case, go replace them. Remember, they would have to have had actual harm happen to them for them to have an actual claim. They can ask you to test them and change them if they're installed. If they don't work properly, you are required to maintain them. But if they haven't asked, just go in and do the changes, make sure they're updated. There is no cause of action in this case because A, they didn't ask and you refused, and then B, no harm actually came to them. So I hope this was helpful to all of you who hung around. I enjoy our chats that we have here. Again, I will post the full chat online. It should be available soon for any of you who want to do a rewatch. Maybe you missed part of it. But thank you all for your contributions. Keep asking questions. I will continue to do these chats on Wednesday afternoons. And until next time, landlords, happy leasing.